special session of the Judicial Tax Commission of the State of Michigan now in session. The Honorable John H. Halsey, presiding, United States, and the State of Michigan, the Congress of
I think I'm just gonna use my timer. Okay. Okay, I'll do that.
Do this. We gotta watch. Here, you go back. First. Well, because you'll come through that. Good.
Good morning, everybody. Welcome. I am Judge John Halsey, Chairperson of the Michigan Judicial Tenure Commission. Pursuant to Michigan Court Rule 9.241, the commission is conducting a public hearing in the matter of formal complaint number 101 in re Kahlilia Y. Davis, a judge of the 36th District Court in the city of Detroit, Wayne County, Michigan. The other members of the commission are, starting toward my right, the audience's left, James Burdick, elected by the State Bar of Michigan. Mr. Burdick also serves as the vice chair of the commission. The Honorable Monte Burmeister, judge of the Crawford County Probate Court, elected by the probate judges of the state of Michigan. Danielle Cheney, one of two civilian members, that is, neither an attorney nor a judge, who was appointed by Governor Gretchen Whitmer. The Honorable Pablo Cortez, judge of the 62A District Court in Wyoming, Kent County, elected by the Michigan District Court judges. Siham Awada Jafar, the other civilian member of the commission, who was appointed by Governor Whitmer. The Honorable Amy Ronayne Krause of the Michigan Court of Appeals, elected by the state's appellate judges. Thomas Ryan, elected by the State Bar of Michigan. The Honorable Brian Sullivan, judge of the Third Circuit Court, Wayne County, elected by the State Bar of Michigan membership. Again, I am Judge John Halsey of the 20th Circuit Court, elected to the commission by my fellow Circuit Court judges. I would like to thank very much the Court of Appeals and its wonderful staff for allowing the commission to use this courtroom for this public hearing. The Chief Clerk of the Court of Appeals, Jerry Zimmer, and Joanne Lang, the clerk for this district, the first district, have been so helpful in making the arrangements to allow us to be here today. I would also like to thank Homero Hinojosa for providing security and for other services. We are now ready to proceed to the hearing. The record should reflect that the disciplinary co-counsel, Robert Kalick, is participating, as is disciplinary co-counsel Dina Dejani. The respondent, Judge Davis, is participating along with her attorney, Michael Swartz. By way of background, on March 16, 2020, the commission issued formal complaint number 101 as to the respondent. The Supreme Court issued an order on June 17, 2020, suspending Judge Davis with pay on an interim basis. The commission filed an amended complaint on March 23, 2022. The Supreme Court appointed the Honorable Cynthia Diane Stevens, a retired Michigan Court of Appeals judge, to hear the evidence. In its order appointing Judge Stevens as master, the Supreme Court directed the commission to submit its recommendation to the court, if any, by September 29, 2022. A public evidentiary hearing was held over 6 days in July 2022. The master issued her report pursuant to Michigan Court Rule 9.236 on August 1, 2022. Each party filed briefs and responses addressing the report. Today is the date and time set for the public oral argument on the objections pursuant to Michigan Court Rule 9.241. The commission will refrain from asking questions during the oral arguments until I inquire of each commissioner if he or she has any questions at the conclusion of each presentation. Each side will have a total of 30 minutes to argue its case. We have a timer here, and I will let you know when you have 5 minutes of your argument time left. Disciplinary counsel has the burden of proof, so you will have the opportunity to argue first. If you wish to reserve time for rebuttal, please let me know at the start of your argument how much time you wish to reserve. You may begin. Mr. Kalick, I believe you're going to argue.
Thank you, and good morning, commissioners. And yes, if I do have any time remaining, I would like to have that for rebuttal.
Thank you.
We've already submitted extensive briefs in this matter, and I cannot go over all of it, and I would not take your time simply to repeat what's in the briefs. What I'd like to do this morning is to highlight areas that I think are important for the commission's de novo review. Begin with, I'd like to provide a brief framework for the commission for analyzing Judge Davis's actions, conduct in this case. Testimony of the witnesses, including herself, the documents and all the records show that she is unable to hold herself accountable for any action. She deflects, often raising non sequiturs in response. She dissembles, and more importantly, she's recalcitrant. She's resistant and uncooperative with authority, at times openly defiant, at others passively aggressive, but always resisting and dismissing that rules apply to her. With this in mind, I want to begin talking about count 4, and specifically the issue that was raised in the complaint of Judge Davis disabling the video equipment. Understand her motives, it's necessary to start with her conduct going as far back as what's set forth in count 2. And that began in September of 2017, where she announced that she would dismiss any case in which Myron Bell was a processor, going so far as to place a notice on the podium in her courtroom instructing parties not to use Bell as a court officer. When Chief Judge Blunt learned of this, she entered an order, that's Exhibit 22, ordering Judge Davis to cease and desist from dismissing cases for lack of service based solely on the identity of the court officer or process server, and further, that any case she had dismissed should be reinstated. In response, Judge Davis blatantly disregards the order and continues to sua sponte dismiss cases in which Bell is the process server. First, she does this under the guise that a lease or deed must be attached to a complaint, which the master properly concluded was specious and not required under the law, and simply a cynical and transparent pretext to circumvent the chief judge's order. Second, during hearings on October 6th, when an attorney tried to present a case in which Myron Bell had been the process server, Judge Davis continued her defiance, more openly stating on the record in Exhibit 29, pages 7 through 8, I don't care what the chief judge or anybody else at this court says. This is my courtroom. And if you have a problem, anybody can take it to the JTC. She continued to dismiss or adjourn cases in defiance of the chief judge's order, instructing on the record in open court as late as October 11th, do not use Myron Bell in my courtroom as a process server. This is set forth in Exhibit 11 at pages 19 through 22. As a result of this continued defiance of the order not to dismiss or adjourn cases, Chief Judge Blunt issues an order on October 20th prohibiting Judge Davis from presiding over any case until further order, and she should continue to report to work on a daily basis. I would point out that this exhibit is referenced at page 20 of our initial brief. It is referenced as Exhibit 22. This is a typographical error. The correct exhibit should be Exhibit 40. And I apologize for that error. After entering this order in October, there's a series of emails between the chief judge and Judge Davis. Chief Judge Blunt emails her asking her to confirm that she is reporting to work each day by submitting her arrival time to the chief judge's office. Davis responds first by basically saying, you can figure it out yourself. She says specifically that there's cameras in the building that would reflect her arrival and departure time. And the chief judge has the capability to review these films and determine whether or not Judge Davis is arriving at work or not. Chief Judge Blount responds saying this is unacceptable and asks again for Judge Davis to report pursuant to her request. At this time, Judge Davis responds, demanding that the chief judge provide a list of all other judges who have to report arrival times. This series of emails is set forth as exhibits 41 through 44. Thereafter, instead of simply reporting her arrival time by email, Judge Davis enters into a long series of disrespectful and insubordinate emails containing quotations from the Bible, which are all set forth at exhibits 45 through 54, 56, and 59. The following month, on November 27th, at the direction of the Michigan Supreme Court Administrator Milton Mack sent a letter after preparing a 10-page performance improvement plan, which hereafter I'll just refer to as the PIP, to address issues that were facing Judge Davis in an attempt to strengthen her performance as a district court judge so that she could be restored to hearing cases as soon as possible. This letter is set forth as exhibit 55. The PIP is attached to a document exhibit 58. Judge Davis refuses to sign the plan. However, it goes into effect, and Scale Regional Administrator Paul Peruk, who was a former district court judge for approximately a quarter of a century, was assigned to work with Judge Davis to oversee and monitor the implementation and progress of the PIP. Both Chief Judge Blount and Judge Peruk testified concerning relevant events that followed thereafter in 2018. Judge Davis in many ways continued to be recalcitrant, but she did have some successes and did meet some of the requirements of the PIP. This was basically in the area of shadowing other judges and receiving additional training. And as a result of this, Judge Davis was assigned to be an auxiliary judge in spring of 2018. She remained as an auxiliary judge until December of 2018. But during this period of time, she would have periodic meetings with Judge Peruk. One of important note is a meeting that occurred in November 2018. This was done at the request of Judge Peruk to review Davis's progress or lack of progress and to make revisions in the PIP to address her ongoing problems. More detail about this is set forth in Judge Peruk's testimony at pages 147 to 151 and 158 to 162 of the hearing transcript. He also prepared the revised PIP, which is exhibit 69, and this sets forth in detail the problems that were occurring in November of 2018, which he addressed with the judge, but also set forth a good narrative of the meeting they had in November. Of important note was during the meeting in November, Judge Davis told Judge Peruk she would not follow a performance improvement plan regarding her times of attendance at the courthouse. She added that the court staff lies about what time she arrives at work and what time she leaves the courthouse, and therein lay part of the problem. Judge Davis was supposed to work the felony docket during the week of Christmas with the other least senior judges And there was a dispute that arose whether or not she was authorized to take a vacation during this time, whether or not she reported to the court, whether or not she obtained a judge to fill in if she was not there. And this became a matter of dispute again with Judge Peru. Her absence lasted till January 17th. Upon returning to work, she was assigned to the business license docket. Her first day in the business license docket was January 22nd. She was assigned to courtroom 340, which is a video courtroom. She was assigned to the video courtroom because for the past year, she had not had a permanently assigned court reporter. And the court policy was that anyone without a permanently assigned court reporter should use video recording equipment. This policy was a result of restrictions in the union contracts regarding contract court reporters. Diane Drew was Judge Davis's courtroom clerk and was there in courtroom 340 on January 22nd. Ms. Drew testified that when the judge entered the courtroom, she was upset and told Ms. Drew, "They're not recording me, I don't trust them." Ms. Drew then saw Judge Davis disconnect the video equipment. And when she disconnected the equipment, the lights on the video system went out. Now, it was described in the testimony that the system would have two lights, a red light and a green light. The red light would indicate when the system was ready to be used, but was not yet turned on by the judge. The green light would come on once the judge pushed the button to operate the system. The fact that the lights on the video equipment that was on the judge's desk was extinguished when she pulled the plug demonstrated that it was no longer operable. Morgan Harrison was Judge Davis's courtroom officer this day. She also testified that Judge Davis disconnected the cords. Now, in her reply, there is a long series of portions of transcripts regarding Ms. Harrison's testimony, but I would point out that it stops at the most critical point. Because what's missing from the transcript excerpts provided by Judge Davis is that Ms. Harrison said that she couldn't see exactly what was happening because of the judge's bench, but she knew that she had disconnected the cords when Judge Davis pulled them up from under her desk and put them on the bench. At this time, Judge Davis directs Ms. Drew to call for a court reporter. One was not sent due to the previously described court policy. Nevertheless, after disabling the recording equipment, Judge Davis proceeds hearing cases that day with no record. Elizabeth Mullins, who at the time was assistant corporation counsel for the city of Detroit and was assigned to Judge Davis's courtroom, who was Judge Mullins is now a district court judge, became suspicious that day the proceedings were not being recorded because the lights on the devices at counsel table were not on. This is set forth in the hearing transcript at page 325. Judge Mullins reported this to her supervising attorney, Shannon Walker, And 2 days later, Judge Mullins appeared in a case again before Judge Davis. And this time, the city wanted to appeal Judge Davis's ruling. They were unable to do so because no record of the proceeding was available. Judge Mullins reported this to her supervisor, Ms. Walker, who then went to talk to Judge Davis to inform her that she had learned the proceedings were not being recorded. Judge Davis responded, "Yeah, I unhooked that shit," adding that, "I told them I wanted a court reporter. They didn't train me on how to use this, so I unhooked it." Notwithstanding all of this testimony, the master concluded that disciplinary counsel did not prove that Judge Davis disabled the videographic equipment based on 2 points. Finding that both Ms. Drew and Ms. Harrison were credible in what they saw, she concluded that because of where their desks were in relationship to Judge Davis's bench, they had a, quote, severely limited visage. As Ms. Drew testified, she wasn't at her desk, but was standing and could see the judge underneath the table, saw her pull the plugs, and then saw the lights on the equipment extinguished. The master never addresses this point. The second point she relies on is she misstates the testimony of Judge Mullins, who she states when Judge Mullins discovered that the taping was not being done because the lights on the microphone attached to and dependent to the central unit were red. The fact that they were red connoted that they were receiving power but not taping, as opposed to completely disassembled. This was not Judge Mullins' testimony. Her testimony is that the lights at counsel table were out. The master never addresses the omissions of Judge Davis that she unhooked the system. And for these reasons and the reasons we set forth more fully in our brief, the evidence is clear that Judge Davis disabled the video equipment as charged in the complaint. I'd like to move to allegations in count 6, and especially looking at the vulgar and threatening statements that Judge Davis made to Ms. Starkey. Master discounted Ms. Starkey's testimony because Judge Davis was soft-spoken during the proceedings that occurred a few months ago. How Judge Davis acted a few months ago is not evidence of how she acted 3 years ago in the parking lot of the fitness center. The record reveals a very different Judge Davis at the relevant time. Reveals a person who defies a court order from the chief judge and says in open court, "I don't care what the chief judge or anybody else at this court says." It shows that when ordered by the chief judge to report the time of her arrival at the courthouse, she initially responds, "You figure it out." She then sends a long series of rude, disrespectful, and insubordinate emails to Judge Blount and Judge Peru. She refuses to sign the performance improvement plan. She told Judge Peru in November 2018, she would not follow any changes he made to the PIP. In response to the changes that Judge Peru did make in the PIP, he sent an email, which is Exhibit 70, seeking information concerning her adherence to the new attendance policy that he imposed. She belatedly responded in an email that's Exhibit 71 by saying, "First, I arrived for work on both days. No, I did not check in with anyone, and no, I will not check in with anyone else. And until the requirement is the same for every judge in the state, please find someone else to harass." In response to the second question asked by Judge Peruk, she responded, "I'm currently assigned to the business license docket," which I did. I will not be calling in to check, I will not be calling to check in with anyone at any time unless and until the requirement is the same for every district judge in the state. Please find someone else to harass. In response to a question whether she signed out as directed by the revised performance improvement plan, she answered, "No, I did not, and no, I will not, unless and until the requirement is the same for every district court judge in the state. Please find someone else to harass." She concluded by saying, "Because of ghosts of judges past were otherwise occupied with exchanging their black robes for white robes and could not do my docket for me, I went ahead and adjudicated the business license docket to which I've been assigned. I sincerely wish you, Judge Nancy Blunt, and Kelly Moore would find someone else to harass." All this demonstrates anything but a quiet demeanor. Anyone who could treat court administration, other judges, and scale and ministers in this manner could certainly treat Mrs. Starkey to a profane and threatening tirade. Moreover, Judge Davis's overdeveloped sense of entitlement, as demonstrated throughout the record, and more specifically by her misuse of the Detroit Police official business placard in her window while parking illegally at the fitness center and approaching the investigating police officer and gratuitously identifying herself as a judge and presenting her badge and identification in an obvious attempt to influence or intimidate the officer, demonstrates character issues that must be weighed heavily in the balance when making credibility determinations when reviewing the record de novo. I'd like to turn to count 7 and 2 of the misrepresentations that the master addressed in her report. The first regards the misrepresentation regarding training and holding Jerry Johnson in contempt. In a very terse findings of fact at page 28 of the master's report, she states that Judge Davis had the following formal training as of October 2017, which is when Mr. Johnson was held in contempt. She cites first that Judge Davis attended the November 2016 pre-bench seminar that was focused on transitioning judges from private practice to the bench. She adds, it did not cover contempt procedures. Second seminar, the master reports, is that Judge Davis attended the March Michigan Judicial Institute New Judge Training Seminar. And third, that Judge Davis attended an abbreviated orientation at the 36th District Court that included meetings with heads of departments and including some shadowing of sitting judges. This was abbreviated because when it was initially put on for the new judges, Judge Davis was sick and was unable to attend. The master concludes a question from JTC counsel Clark, to which Judge Davis responded that she had no training was, did you give Mr. Johnson due process before sentencing him to jail, knowing what you know now? Judge Davis answered, knowing what I know now, no. But at the time, I did not know that because I didn't have training. With no analysis, the master states, the petitioner failed to prove the allegations of misrepresentation. But what the master didn't consider that's in the record is in the deposition transcript that's Exhibit 129 at pages 12 through 13, Judge Davis stated that she had graduated from Wayne Law School in 2006, was admitted to practice in 2007, and practiced approximately 9 years as a criminal defense lawyer in Detroit prior to her election. This latter information appears at page 16 and 17 of Exhibit 129. This would show considerable considerable training in due process. As I mentioned before, Judge Davis was sick and could not attend another seminar that was in January 2017, which was a new judges program, but she did receive all of the written materials from that program, which were 2 binders full, in January of 2017. To complete her 36th District Court orientation, Judge Robinson was made available to her for 2 days on April 10th and 11th to mentor her and offer guidance and answer any questions she may have. This is set forth in an email from the court to Judge Davis, Exhibit 127. This would show substantial training that Judge Davis would have received regarding due process. But what struck me was the comment that the master said that the 3 training sessions that she referred to did not cover contempt proceedings. But the master missed the relevant information. As part of the 36th District Court orientation, she received an email from the District General Counsel and Judicial Assistant of the court on March 14th, 2017, that it contained, among other things, links to the Michigan Judicial Institute bench books, which would include the bench book on contempt. She had this in March 2017. That email is Exhibit 126. This link to the Michigan Judicial Bench books was resent on May 9th, 2017 to Judge Davis, and that's set forth as Exhibit 128. Clearly, she had all of this material months before the proceedings regarding the defendant at issue. The statement that she didn't receive any training is clearly false. She had substantial training and experience regarding due process and the rights of defendants. She also had specific training with having access to the contempt bench books. What I found most interesting is in her report regarding count 1, which dealt with this issue with Mr. Jefferson, the master, in her findings of facts and conclusions of law set forth at page 8, paragraph 6, said Mr. Johnson was denied any semblance of due process. He was not appointed counsel nor given the opportunity to hire one himself. He was not given the opportunity to defend himself beyond his answer to, "Do you care about due process?" The contempt proceeding against Mr. Johnson was utterly devoid of due process. The respondent abused its contempt powers regarding Mr. Johnson. At the time of the Johnson hearing, the respondent had received and read the Michigan Judicial Institute new judge course books and was aware of the existence of the Michigan Judicial bench books. Clearly, misrepresentations that are alleged regarding her training were proven. The second misrepresentation that I'd like to address is the one that the master put in her report, and this deals with Judge Davis's residence. The master rests her entire conclusion that there was a failure of proof of misrepresentation because, quote, there was no stipulation in the record nor testimony in the deposition transcript in the case of Davis versus Wasner as to when the accident occurred. Therefore, there was no basis to find that she testified under oath that she lived alone at 430 Frederick on August 29th, 2017. This is on the master's report, page 20. The master is simply incorrect on both counts. Even a cursory reading of that transcript reveals that at page 39, lines 12 to 15, she was asked, let's talk about the accident.
You have time. You have exhausted your 30 minutes.
Thank you, Your Honor.
I will now inquire whether any commissioners have any questions for Mr. Kalick. Commissioner Burdick,
No questions.
Commissioner Burmeister,
No.
Commissioner Cheney,
No.
Commissioner Cortez,
No, thank you.
Commissioner Jafar,
No, thank you.
Commissioner Kraus.
Yes, I do have some questions. Actually, I think the issue regarding the last point that you were making is on page 28, because page 20 in the master's report is about Ms. Walker's testimony being incredible. And so, let me move this a little closer. What I have to ask about that is, she said that Ms. Walker was not credible, yet it seemed to me that there was a request for a transcript and the transcript couldn't be made because there was no recording. Do I have that right?
The transcript that couldn't be made was a recording of the proceedings in court
Yes,
because she was not using the video recorder.
that's what I'm saying. So just go ahead.
Go ahead.
Okay, sorry. All right.
Did I misunderstand your question?
No, you didn't. No, I was confused because the other counsel was standing up. So, okay, so no, you didn't misunderstand my question. It's to me, it seemed that there was a request for a transcript, that hearing transcript, and Ms. Walker couldn't get the transcript because it hadn't been recorded by the judge. Is that right?
That's correct.
Okay. Then I want to go to pages 24 and 26 of the master's report regarding the parking. What I found significant is it doesn't seem that the master gave much credence or much weight to the fact that there was this placard in the car. I mean, did you agree with me about that? That it seems like that was kind of brushed over and not really taken very seriously.
I agree.
Okay. All right. And then on page 28, I do want to go back to what you were saying about the address. And I'd like to know, like, first of all, in paragraph 2 of the master's finding, I didn't understand that finding. Did you? I mean, can you explain to me what that means? Because I can't.
All I can say is, as I understood it, the judge was saying there is nothing in the record that indicates what time the day of the accident was, nor the statement regarding Judge Davis's living arrangements.
And that's not true.
That's not true.
Okay, that's okay. Good, because I didn't think it was true and I thought I was misreading that completely. And then paragraph 3, and this is, I promise, my last question. I shouldn't do that because I'll probably ask another one, right? In paragraph 3, the respondent has continuously averted that her vehicle was legally parked at the LA Fitness in a loading and unloading. Well, it says in a loading and loading. I think she means in unloading zone. But she said that there's no misstatement because she said that there was a handicap sticker and it was a handicap spot. Can you respond to that a little bit more for me?
Certainly. Where Judge Davis was parked was in the area that's reserved so that handicap accessible vans can unload people who are in wheelchairs, who need the lift to take them out and down from the van, and to then put the wheelchair back on that lift so they can raise them back into the van.
And is that is marked that way, right? As a loading and unloading zone, correct?
It is marked with slanted lines next to the handicap space.
Okay. All right. I don't have any other questions. Thank you very much.
Commissioner Ryan,
I have no questions. Thank you very much.
Commissioner Sullivan,
No questions. Thank you.
I have no questions. Do any other commissioners have any other follow-up questions that they wish to ask? Mr. Swartz, you may now proceed.
Honor, the reason I stood up is prostate problem and I need to have a break. That's why I stood up. So I'm doing the best that I can. If I can take a break right now for just 5 minutes.
Absolutely.
Thank you so much.
We're in recess.
All right.
Wonder why it's so crowded. Somebody's taking 2 spaces.
Yeah.
Sound. Can you hear me? Okay, good.
No, this one.
Mr. Schwartz, should we wait for your client as well?
Yes, I expected she was in the ladies' room.
That happened to my cat. Yep. Oh, right on. The hatchback? Yep.
The worst court for us is Grand Rapids. Grand Rapids still look like when I started, first thing he said to me is, when you go to Grand Rapids,
Well,
it's a
I
ramp.
shifted just a bit. I know, but if you go in it's first. Sorry for the delay.
All right, we are back on the record. Mr. Swartz, you may proceed.
Thank you, Judge. And thank you, all members of the Tenure Commission, for having me allowed to make my statement for my client. This has been a long case. Goes back to April 7th of 2017. That's 1 month and a day from the time that my client took the bench. She wasn't able to do it initially because she had medical problems, which has been indicated throughout, and it's very clear. The Tenure Commission has been very good about recognizing the fact that she did have, in fact, medical problems, and that did, in fact, make it difficult and in some cases impossible for her to appear in court because she had to be hospitalized in certain cases and other things. Nevertheless, on April 7th of 2017, she was given a request for an investigation. And I've seen these things in the past. I know Ms. DeJani has seen things like that in the past as well, because we've had experiences with the Attorney Grievance Commission, and you get requests for investigation. This one was most interesting. I'm not going to get into it too deeply, but it had a lot of things in it that didn't appear at all to have anything to do whatsoever with any improper conduct by my client. There was a lot of other things that were asked. For example, they want to know, when was she sworn in? As if they needed to know that. Or who swore her in? I don't know why that would be in there. Or describing every place that she went to during court business hours other than the court in her own home between January 1st of 2017 and April 7th. I only mention that because we have to look at this picture in context of everything that went on, not just simply the things that we heard earlier today. My client was subject to a slew of requests of 28 8-day letters and other documents. There was one on May 28, 2020. It's the first time I got involved with this. It was 63 pages with 252 paragraphs and an additional 449 pages of attachments. It was very long, very difficult to get through. There were others, not quite that big, but some of them rather large, involving such types of requests that were dated June 15th of 2020, July 7th of 2020, January 10th of 2022. 3 formal complaints. Now, I'm not sure what you do here normally because I don't really come in front of the Tenure Commission, but it seems like a lot. And it seems like a lot, this entire case, when you look at it, has certain aspects to it, which we will look at. Now, it was difficult because of these types of communications and responses that we were required to have defense on a lot of these claims. We did it anyhow. And I do want to say that the Tenure Commission was very good in providing us with necessary time, because it was very difficult to get all this done within a certain period of time. Plus, as it may be strange to believe, I actually have other cases than this one. But they were all sent and everything was done, and the Tenure Commission made it possible, because otherwise we could never have had this happen. Now, there were basic problems that were claimed against my client. Some of the charges alleged that my client failed to discharge administrative responsibilities such as being ineffective in having an official record made of proceedings in the courtroom. There were also other claims that my client failed to avoid certain situations, such as holding a contempt hearing without having due process. There were also claims that my client did not pursue matters properly in the use of video recording devices. And there were a number of others that were set forth in the second amended complaint. Now, those were the accusations, plus all the other ones. The problems, the major problems, stem not from my client's wrongdoing, and I'm willing to admit that she made mistakes, but by those who were her supervisors, and in particular, the former chief judge of the 36th District Court. Those two problems that were created by Judge Blount included first, training. Now, as we know, my client was not available to come in to the court until March of 2017. That's because of her medical situation, hospitalization, recuperation. She wasn't able to come in. When she did come in, she was not given training the way it was given to the other new judges. There were two others who came in the beginning of 2017. Apparently, Judge Blount decided that for whatever reason, she wasn't going to be able to provide the same kind of training that were given to the other judges who came. And there were training, and brother counsel said, well, we had books. That was training, books. I think it's good to read books. It's an awful lot to read all that at one time. And with all due respect, books don't necessarily explain things that would be explained if there was a judge who was there to be able to assist in that. It's one thing to read all these books. That doesn't necessarily mean that once you read it, you know it forever and you know it fully and you were able to discern what or what should not happen. And there may be certain aspects that require that there be some kind of work that needs to be done that could use the kind of training that one gets normally, which was not provided to my client. Second problem, my client was in a situation, and this was when she was primarily in room 340. In that room, there was video equipment, just like there were in every other courtroom in the 36th District Court. 28 judges were the number that they had in the 36th District Court. Of the 26 judges, all of them having the equipment, 25 of them had court reporters. There were two new ones who came in at the same time that Judge Davis came in. Those two elected to have court reporters. They had not previously had the role of being a judge. They did not have court reporters to their matter, to their courtrooms before they first came in. And at one point, we had during the hearings, and it's important to look at those hearings because it kind of helps you a little bit. And I'm sure that you've done that. Judge Blount very simply said, well, they really didn't have to take, as she would say, the video recorders. Now, if they didn't have to take the video recorders, and it turns out of all of the 28 judges, it was only one judge who was compelled to use the video recorders. 2 of the 28 opted to take that. 25 opted not to take that. And my client was not given the right to do what every other judge did. Now, to put it simply, that seems to me to be discrimination. Why was one person singled out from all of the 28 by the chief judge? But let's go further. Judge Blount had been required not to have anything but what is allowed for her to have. And according to what well, let's put it this way. We heard from brother counsel that there was a policy that was there. And for some reason, that policy was applicable to one person. He didn't say that part, because it didn't apply to anybody except for this individual, this judge. All right, why is that important to know? What Judge Davis was looking for was just fairness in allowing her to do her job. She was not given the training that all the others were given. She could have been provided with a certified person who had video knowledge and video training to do that job that almost every one of those judges didn't want to do. She was not given a court reporter except on one day. And then after that, she wasn't allowed it at all. It was asked continuously, Judge Blount, please give me a court reporter. She refused. Judge Blount just allowed, she knew what was going on. She actually testified. She was aware of what was going on. It's not like she didn't know. Things were been brought to the attention of the court administration. And when asked on cross-examination, well, did you know? And eventually she said, yeah, I was aware. She was aware of all that, but she didn't do anything. My client is sitting there. Now, in part, as I said before, she did make some mistakes. There's no question about that. And I will say something else, because it's important to know. There were claims that my client didn't take time that she should have had to be in the courtroom. Now, there are 72 months in a term. Right now, as we sit there, there's 68 and a little bit. And during that time, we have, and I'll just make it 69 months just for, make it easy. Since January of 2017, the respondent had medical leave in the amount of 3 months. The amount of time that she was allowed to work, and I say allowed because it's something when you look at, you'll see why it wasn't allowed. 15.2 months. There was prohibition of work. In some cases, she was not allowed to adjudicate. She was taken off of that. She was taken off of dockets. There was a period of time, 6 months, where she wasn't even allowed, or actually the way it was put, she wasn't required to come into the court at all, to the building. And the last part, of course, 2 years and 3 months have gone by since she has been prohibited from doing anything as a judge because she's been suspended interimly. Now, again, I don't know everything that goes on, but I think that's probably one of the longest periods of time that anybody has spent that amount of time in interim suspension. It's just, I'm not going to get into further with it. That's where it was. So the total amount of work that she was prohibited from doing overall, 49 and a half months. That we should know, because it affects everything that went on with her. It wasn't her fault. Now, she also had some other problems. She's got a disability. She's had disabilities from before she even started as a judge. She was given a courtroom back, I think, at the end of 2017, more or less. Room 340. It was overall on one side. I actually went with her to see what it looked like. On one side of the building was 340 courtroom. You go all the way down to the other side, and it's not a small amount, all the way down, and you went to the other end, and that's where you have the chambers. And she had to go back and forth in those chambers. It was very difficult for her. I saw when she went down the road, as it were, I could hear her trying to breathe. She was having difficulties in doing this. It was not easy. And she was put in that position by Judge Blount. And you've got to ask yourself, why is it that that was done that way? Why was she so separated? The question, because it goes to everything else that happened. Now, we have a master, Judge Cynthia Stevens. I remember being in front of her way back, Wayne County Circuit Court. We had a trial going. It was pretty good. She's a really, really good judge. At least that's what I believe. And I saw her as the master in what she was doing, presiding over the hearings that we had over the number of days for this case. She really does a good job. I think as a master, she does what should be done. Now, there are one or two parts of what she did that I didn't agree with. But for the most part, she looked at what happened. She has the time to do something that most of you cannot do, and that is to be there in presence when the court hearings are taking place. And the court where she was presiding, she was able to discern in terms of credibility the witnesses. And she was very good. She went out, for example, in the case of Starkey, which Brother Counsel mentioned. She took a whole part, and I believe it was in, toward the end, I could actually find this thing over here. And just at the end of count 6, Judge Stevens, there was a large part, page 25, a large part, number 4. She took an awful lot of time detailing what was going on as to why it was that Ms. Starkey was not credible. This wasn't just something that she did flippantly, quite to the obvious. When you look at that, you realize she did what needed to be done, because she doesn't just simply decide to do something without actually taking the time and the effort to do what is required. Now we take a look at some of these things that we've got. Myron Bell. Myron Bell, he lied. He lied when he said that he was process server serving a process. He signed proof of service. And in so doing so, he lied. engaged in fraud. And on cross-examination, when asked about, well, is this what you do normally? He says, well, done at least 5 or 6 other times. There's a person, and you've got to ask yourself, wait a minute, he didn't serve. He didn't know anything about the person who did serve the one document that was put in, not on August 26th, as he put in on the proof of service, but on 29th of August, 2017. Now, he was not credible. This all went through when we're looking at the hearing, because that's one of the things that masters do. They check to see whether or not they believe, if they can discern it, whether or not the witness is credible. She said he wasn't credible. It's good reason for that. My client, before all this thing went on, she was there at the Frederick residence. I believe it was 4:30, could be wrong. She was there. She was in the driveway. She saw somebody come up on the 29th. She didn't know who it was. And then it left. That person left. Then she looked at what there was. And then it turns out there was this claim by Mr. Bell that he's the one who served it on a date that didn't even happen. Now she goes out and says, well, gee, that she knew before the hearing. That's something that you say, wait a minute, that person is not reliable. That's somebody that you don't want to have in the power of justice. Because when people come in and they lie to the court, that's serious. Now, the rest of this, you know. There was also Bible verses. Oh, did we take a lot of time talking about Bible verses? The master decided, after going through everything, that those Bible verses were not anything that required that there be discipline as to that aspect of what was going on. And properly so. There was nothing in there that took those Bible verses straight out from the New Testament, took that out, and somehow or other turned that into something which is a violation of the rules of judicial conduct, the code. I don't think so. You've got to have something a lot more than that. And that's what the master said. You don't have anything more than that. These people who came to that said, oh, we were very terrified by all this. But they never actually came out and say why, because there were Bible verses and somehow or other that was supposed to be used to terrify members of the court. Well, that was their thought, but there's nothing that was brought out in the course of the hearings or in the course of anything that showed that that was what was intended by my client. Then there's court proceedings without official record. No question about it. My client admitted that. Why did that happen? It happened because she wasn't given the resources from Judge Blount and the court administration of that court to have either have the video equipment brought in by somebody who knew what to do, who had the ability to do this, who was trained. That never happened. Getting a court reporter that could have come in, that didn't happen. None of that could happen because she was prohibited from getting that. So what she did, the one thing that she could do, she tried her best, and she had it taken on her cell phone. At least that was the only thing that she had to show what happened. Now, that's not an official proceeding reporting. But what else was she going to be able to do? Why was it that the court chief justice did not give her what she should have had? What everybody else there should have had? That's a problem. When we take a look at the publication of court proceedings, once again, the master concluded that the petitioner did not publish these recordings. And she didn't. And there was nothing to show that she did. You can have a situation where somebody has put it out there, but can you say that it was her? Could somebody else have taken that somehow and put it up there? Who knows? There was insufficient evidence, because one of the things that we know, you've got to be able to show what it was by preponderance of the evidence. That we don't have here with that. And because we don't have there with that, that cannot be a basis upon which to have discipline. Handicap parking. That's a parking ticket. My client came out, she's got stickers on the back of her license plate showing that she's handicapped. She's got that. She had all these other things in many different sources from the state or otherwise, from the Secretary of State, that show that she had that. Okay, she ended up going into a spot that was used to bring in or take out certain types of things, such as a walking thing that she has to have, just like what you've got over here. All right, she admits that that's what she did. She's not trying to do anything other than just simply say what there was. And I should tell you that with regard to Officer Gianni, who was the police officer who was there, he asked her, does she work? He asked her, do you work for the city? And that's when she came and showed her badge, took it out and said, here, I'm a judge. Okay, because that was in response to what he talked about. She didn't just say, oh, by the way, you know, look at what I am. I'm a judge. It's not the way she did it. Now, we have to admit, she made a mistake. Yep, she did violate an ordinance, and that clearly is whatever it is. But every time you get a parking ticket, if any of you get a parking ticket, does that mean that you should be subject to discipline? Well, the master didn't think so. And that's why that was taken down. That's why that was not brought in. But with regard to the other part, which had to do with the placard, et cetera, if you take a look at her report, she did include that as one of the things that she found to be a violation. I don't know why there was some suggestion that she did otherwise. She did that. She honestly said, yeah, this is what I did. And the master said that was violation, period. Not everything was violation. Part of the other stuff was considered by her not to be proven. The misrepresentation, a lot of that stuff was from before what we had in a number of these other briefs that were put out. But they were really shown in every one of these not to be proven. And I think the master was correct in that. Now, my client has made a lot of mistakes, but none of them, not a one, involve moral turpitude, dishonesty, engaging in narcotics traffics, harming young children, stealing money, or other such heinous conduct. And that's where you really want to go. People who are doing real bad things, those people deserve to have appropriate kind of discipline. It's not what we have in her case. And to a large extent, what happened was the result of what Judge Blount did. Now, for 5 years, my client's been subject to terrible pressure, stress, along with serious health problems. It is suggested that the master performed professionally, and except with a few minor exceptions, her report should be adopted by this commission. And it's further suggested that no further discipline should be imposed against Judge Davis.
Thank you very much. Right before the buzzer. Good timing. I will now inquire whether any commissioner have any questions for Mr. Schwartz. I will again proceed via alphabetical order. Commissioner Burdick,
No, sir.
Commissioner Burmeister,
No.
Commissioner Cheney.
No.
Commissioner Cortez.
Yeah, I have a question. These bench books that you referenced, have you ever seen them?
I have.
Okay, we've seen a lot of them. They're basically judging for dummies. You can look up a book on preliminary examination and it'll resolve any doubt you might have about how to conduct a preliminary examination. Whatever, landlord, tenant, traffic, you name it. They're great books. They're great resources. They're all online. You have to buy them for free. As lawyers, you, me, everybody's got a law school, knows that when you want to do something of an issue, you do your research. You go to case law, you go to the library, you go to Westlaw, whatever you're using. Are you suggesting that she didn't have the ability to just, boy, before I put this guy in jail without any due process, I should probably figure out how to do it the right way and just go through the flow chart they give you in the MPI that tells you step by step, literally. You don't need any training. It's all in there.
Judge Cortez, let me just say this. This was being done while she was in the early stages of being a judge. She looked at certain things. I don't think that there's a showing that this was done intentionally by her. Now, the fact is that, yeah, there are books out there, and there may well be that she could have potentially looked at the books at every one and taken the time in every case to do that. If she had to do that each and every time, she wouldn't be able to get her docket done. You know, and I'm not trying to say that these books are not good, because they are. I think a lot of effort was put into them. However, when you go through these things and you've got a docket that's got maybe 15, 20 or more cases, every time something like this comes up, you can't just simply say, okay, I'm going to take a break, go back to your chambers, which is all the way down to the other end, and then say, oh, you know, there is, and then come back and do this. It would be impossible. That's a problem, the way things were. So I'm not disagreeing with you, Judge. But at the same time, I have to, excuse me?
You have to look at it. So the one that you need right now, and what you need right now before you throw somebody in jail, the due process is to figure out how to do that correctly. You have to look at the landlord tenant one, you just have to look at this specific one. The time of the day to do that. You can take a recess. You can convene a week later. You can do all kinds of things. You don't have to do it right on the spot.
Yes, and I'm not actually saying that, you know, let me put it this way. The master said that what Judge Davis did was wrong. I'm not disagreeing with that either. But at the same time, we have to look at what there is in the context of everything and then look at it for what it's worth in terms of how you're going to dispose of the disciplinary question.
Question I have is the whole thing with the disconnecting. The proper solution, if you think you're being treated differently than all the other judges, as far as giving a choice of not using a recorder, wouldn't it be better to go up the food chain, you know, go up to your chief judge? If you can't get satisfaction there, go to SCAO, your regional. If you can't get satisfaction there, maybe you can file a GTC complaint and say, hey, I'm being discriminated against by these other judges.
Yeah, you know what? We can all take a look at things and in hindsight say, you know, maybe we should have done that. Of course, it might not have happened quickly enough to really, you know, do what's necessary. I guess maybe the better course would have been to go out and either go to this entity or some other entity and say, hey, this needs to be done. But it takes a while. I can tell you one thing. If it took this commission the amount of time that it's been taking for my client, 5 years, this would never get done. So I understand what you're saying, but there are problems that need to be dealt with. Those problems probably need to be dealt with overall. It may well be that the Supreme Court needs to take a look at some of the way things are going. I'm not getting into that either. But yes, there's always a possibility that you can look for something different than what is actually going on. It didn't happen this way, but that doesn't mean that she violated the code of judicial conduct. Didn't mean that she intentionally didn't want to do it. And that's what I think is important for us to look at, as well as anything else that you've brought to our attention.
All right, thanks.
Commissioner Jay Farr,
No, sir.
Commissioner Kraus.
Yes, I have some questions. How did the recording equipment work in her courtroom?
I can't tell you because I've never seen it.
Well, that's interesting because when I was a district court judge, I would on the weekends, I'd have to do my own recording because it was required because we didn't have a court reporter and we were arraigning people. So you push a button and it starts recording and then you turn it off and it stops recording. So I'm wondering if it's more complicated than that. Is that in the record somewhere that it was so incredibly complicated other than pushing a button? And
Yeah, I think there was more to it than that.
really,
I mean, there's a record.
is it in the record?
Let me put it like this, Judge.
I'm sorry, is it in the record?
I don't recall.
Okay.
It could be, but I will say this much. With regard to what you just said, you take a look at all these issues about the video equipment and whether or not it's easy or hard. Somewhere along the way, all those other judges were given the training.
Well, wait a minute, because if you're going to go into the training and the court reporter issue, on page 90 of the transcript number 1, where Chief Judge Blount testified, she said that Judge Davis did have a court reporter for landlord-tenant matters. And
Yes,
you're
but-
saying, well, I'm sorry, you just said during your argument that she didn't ever have a court reporter. That is in fact untrue.
Well, let me put it this way.
No, am I right? That's what you said.
Let me say that, yes. And she also actually had one time on February, I don't remember.
I know the one date.
February 29th, 2019.
I've read all
something
these
like that.
transcripts.
But here's the thing, I have as well.
Well,
The one
that's
thing that's
interesting because
involved though
you
is
said
this.
something that was untrue.
Well, what we have, when we got into the part that involved the video transcript, the video equipment, at some point she had that. In fact, even Judge Blount at that initial point allowed her to do that. But then she was moved later on to room 340 and that changed everything. And that was in, I believe, October 2017.
Okay, you're not answering my question. Obviously, you don't want to. That's okay. I'll go on to the next one. On page 73 of the transcript, Judge Blount testified that Judge Robinson used video equipment. So when you're saying that everybody else had the access to a court reporter.
I didn't
Judge-
say that. With all due respect, I said, if you may remember, there were out of the 28, two of them used on their option video equipment. One was Judge Robinson
Okay,
and the other one was Judge
all
Blount's
right. My apologies then.
nephew.
All right, my apologies if that's what you meant.
I apologize for what I said as well on what I told you.
That's okay. The Bible quotes, just so that we're clear, these emails, I think it's important for the record that Sovereign Lord, my strong deliverer, you shield my head in the day of battle. Do not grant the wicked their desires, Lord. Do not let their plans succeed. Those who surround me proudly rear their heads. May the mischiefs of their lips engulf them. May burning coals fall on them. May they be thrown into the fire, into the miry pits, never to rise. And it gets worse as the Bible quotes go on. And you're saying that Judge Stevens found those to not be a problem or disconcerting in any way. Is that correct?
What she said was that does not justify discipline in that case. If I
You
can
think
pull
that's
out-
judicial? Do you think that doesn't violate the canons to send an email like that to a colleague
No,
that you're going to burn in hell?
no, that's not what it said.
It says into the miry pits,
That's not
never to
what it said.
rise.
It did not say that Judge Peruk was going to be subject to some
Okay,
kind of
but
problem.
couldn't Judge Peruk have felt that way about it?
Well, at some point when we went through that, when I cross-examined him, he eventually said, well, that's my personal opinion.
Right.
And
That's,
that was what he said. What
Well-
it was not said was when the Bible was written, I don't know who did it. Somebody way back many centuries ago went out and did that. Now, everybody looks at these things. It goes all around. There's nothing in there that Judge Davis said that you, and then take the Bible thing. She just quoted the Bible because she's a very religious person and she just felt.
well,
that
as
she
am
should
I,
put that-
and I know the Bible very well. And if I got that email, that would certainly scare me, but that's just me. And you're saying it's only an opinion, but we're talking about canons, and judges are supposed to do everything with, so there's no appearance of impropriety.
There's no
not
impropriety in
just-
citing the Bible.
Well, it depends on what section of the Bible. When you're saying they're going to go in miry pits and burning coals fall on them, I think that does. So you and I can disagree about that.
Okay.
That's fine. All right. So in the third transcript, you said that Officer Gianni, that the whole way that the badge came out was because he asked for ID.
He didn't ask for ID. He said, actually, and I'll read it to you, that he wanted to know whether or not she worked, meaning Judge Davis, worked for the city and
Right.
what she does.
Okay,
That's what he asked. And she then said, okay, here's my thing. And
Is that in the
answered his
transcript?
question.
is that in the transcript? Because page 293, Officer Gianni asked if you didn't say anything about asking for the city, and he said nothing provoked her showing the badge. So are you telling me that that's not right? Because that's what
Well,
it
you
says
know
in the
what?
transcript.
I've got it. I don't have it in front of me right now. I probably could get it, but I can't get it to you this moment.
Okay, so well, that's what I read. It doesn't say anything about, it sounds like she just offered up her badge. That's the way I
In
read
any
the
event,
transcript.
Judge Stevens said that she should be disciplined for that.
Right.
So that's not even an issue here.
Well, I understand that, but but you said something different. So I'm trying to find out what is true, because I'm reading the transcripts, and what you're saying to us is different than what's in the transcript. That's where I'm coming from.
Okay.
Okay, thank you. That's all my questions.
Commissioner Ryan,
I have no questions. Thank you, sir.
Commissioner Sullivan,
No questions. Thank you.
Mr. Schwartz, I just have a couple of questions. And just for clarification, it may be of some benefit to the commission when we deliberate, and it may be of some benefit if the Supreme Court gets this issue. Your client, is she still on the ballot? I know there was some.
No, she's not on the
Court of
ballot
Claims.
now.
She's not going to be on the ballot?
No, because the Board of, what is it called? It's the Board of Electors or whatever it is. They took her off and she's off. So.
Which of the Court of Claims and the Court of Appeals, I believe, have ruled on this as well.
But it ended up where she will not be on the ballot.
Okay, thank you. That clarifies that. And during your presentation, you indicated that you essentially agreed with the master's report, except for one or two findings. During your oral presentation, I haven't heard you challenge findings. Without getting into the reasons for those challenges, what are the one or two findings of the master that you disagree with?
Let me just, if I may just take a look, because I've got some things here that will help me to say that. So I believe. I'm trying to see this in the notes that I wrote. I don't know. It was not significant enough that it makes a difference. Let me put it that way.
Thank you very much.
Thank you.
I do want to thank counsel and the master for completely complying with the aggressive timetable that the Supreme Court has placed on this case. So thank you very much for complying with each and every one of those time parameters. There being nothing further, Well, I should ask, was there any follow-up questions to councils? Thank you.
thank you.
There being nothing further, the commission will take this matter under advisement and will issue a written decision and recommendation. That decision and recommendation will be a public document and it will be posted on the commission's website. The commission again thanks council for their well-written briefs and their thoughtful arguments here today. And again, we will have our decision to the Supreme Court by September 29. This hearing is adjourned. Thank you.